this segment, I want to discuss the issue of the rule of law. It's the fourth major characteristic of American constitutional democratic government. And in a sense, it's the most critical. In a sense, it's even the first principle, because you can't have majority rule without knowing what the rules are. And that means you have to already have a concept of the rule of law. Obviously, if you're going to have minority rights, you're going to have to describe what those minority rights are. You're going to have to write them down somewhere. We've written them down in the Constitution. But a Constitution presumes that you already have the rule of law. And then there's freedom of expression. We want to say that everyone, even a minority of one, has the right to express their ideas. But that's subject to rules. You can't have someone say they have a right to commit murder, and they go out and commit murder. You have to say, well, you can say that you have the right, but you can't actually do it. And that implies a rule that's there ahead of time. So in a sense, the rule of law is the very most basic of all of the principles of American constitutional government. It is what makes a constitution possible. But what is the rule of law? Well, the rule of law is something you hear from politicians all the time. We're a country that follows the rule of law. Because we're a rule of law, this particular proposal made by somebody violates the rule of law and therefore it cannot be adopted. These kinds of sentences are used by politicians all the time. They're even used by news commentators on news channels and so on. But rarely is it defined. It's not defined because as you go to define it, problems develop for your own point of view. That's the nature of the rule of law. The rule of law creates a platform on which all of us can stand. But another way of looking at the rule of law is that it's a two-edged sword. If you adopt the rule of law, it should be so neutral. So it may help your interest in one respect, but should you choose to violate it, it immediately cuts against you. That's one of the reasons why the rule of law is so often left undefined. In this segment, I'm going to begin the process of defining it, and it will probably take 2 segments to complete this. The first thing to say about the rule of law is that the idea of rule of law goes back to the nature of government itself, the notion that we should avoid violence. We have the problem of sleeping roughly a third of our life away, and while we're asleep, we're vulnerable. So we want to have something that protects us, and we want to have it protect us through law. The first proposition about the rule of law is that the rule of law is above the people and the government. First of all, the people. We want to have the rule of law above the people so that we can avoid violence. Now, what this means is that the government has to be in control of the entire territory that's within its jurisdiction. That's not always easy. For example, the United States in 1803 purchased all of the land belonging to France that was west of the Mississippi River, running all the way to the west coast, somewhere vaguely out there, because they didn't even know where it ended, for sure. When we owned it, it was our land, but we, the American people, who prided ourselves in the rule of law, could not honestly say that we had the rule of law west of the Mississippi River. It was wild. There were just a handful of white folks out there, mountaineers. The rest of it was land that was not under our control. So the rule of law wasn't there. Indeed, it took the next nearly a century before all parts of the West were effectively governed by U.S. troops, sheriffs, police departments, and so forth. There was no rule of law. Secondly, indeed, the rule of law may be missing even in urban centers. If you're in a dark alley in a major city in the middle of the night, and someone's about to mug you, if you don't have a policeman handy, you don't have the rule of law to protect you. So the rule of law is not easy, although people like to pretend that it is. The first proposition is that the government must have control of the people. Now, we can't guarantee it in every instance, but we feel that we have the rule of law if the government's control is so effective that we live comfortably. But this means that we have to resolve disputes with the government. So things like vigilantes, things like feuds between people, they're unacceptable. If there's a dispute that cannot be resolved peaceably, we expect the courts to be places where these are resolved. If these are private matters like a contract negotiation or some dispute over a traffic accident perhaps, these will be handled in a civil court. If it involves a criminal statute that someone's violated, then a criminal court will be appropriate. But in every case, if there's a dispute that cannot be resolved peaceably, we expect the government to answer it, not vigilantes. Because it can't be completely true, there remains a category of self-defense in our legal system. But it's a small category, used only in real emergency situations. Proposition number 1 about the rule of law is that the government must be in control of the people. But the second proposition is that the government needs to be in control of the government, that law needs to prevail over all people. In our country, we do not say that the president is above the law. We do not say that the 9 members of the Supreme Court are above the law, even though they have a large influence in deciding what the law really means. We also don't say that senators or representatives or governors or state legislators or county mayors or city councils, none of these people are said to be above the law. They're all under the law. That's why they're required under the 6th Amendment of the Constitution to take an oath of office that promises to support the Constitution of the United States. They are saying that the law prevails over them. But does it really? Well, in reality it may not, because one of the characteristics of government is that it has a legal monopoly on the use of lethal force. So there will be times when the government will exceed its authority, when false arrests will be made, when people will be falsely convicted, and sadly, even cases, since we use capital punishment, in which people will be executed for crimes they did not commit. We do not have a perfect system, but we aim to try to have a perfect system by putting the government under the law, just as the people are under the law. How do we make this effective? Well, we make it effective by having the third proposition about the rule of law, which is the need for an independent judiciary. We don't know how to perfect the system, but we hope to create it by using an independent judiciary. What does this mean? Well, it means that there's a law that is over all the officials, but who holds them accountable? The only way to hold them accountable to the law is to have some independent group who judges whether a president or the Congress or the governors have exceeded their authority under the law. That's where the judiciary comes in. If the judiciary, however, were under the authority of the president or under the authority of any of the state governments, it wouldn't be much of a force. It would always have to answer to the very people it means to control. So we want to have an independent judiciary. How do we perfect this independent judiciary? Well, we try to perfect it, but we can't guarantee perfection. Here's what we do. If you look at the U.S. Constitution with regard to the independent judiciary, you find that the judiciary is meant to be independent because it is not elected through regular, frequent elections. We insist that members of the House of Representatives run for office every 2 years, that presidents run for office once every 4 years, senators run every 6 years. But for most of our judicial offices in the states, there's an 8-year term. They get a longer term than anybody else. Why is that? Well, they're not said to be a policy-making body. They're said to be a judicial body, judging, not creating the law, but judging whether behavior conforms to the law that's already there. And when we get to the federal courts, something even more remarkable occurs. We insist that the term of office for federal judges be for life. They are tenured from the moment they take office. You can't make them retire. Indeed, when they retire at full salary. They're no longer hearing cases, but they're paid as if they were, because we won't cut their salaries off. They are tenured, and we want to encourage them to retire, because sometimes they're simply too elderly to do the job. The second thing about federal judges is, of course, that there's no mode of election. They're not elected at all. Every federal judge in this country is appointed by the president. But, of course, after being appointed, they still have to be confirmed in the Senate. And they have to be confirmed in the Senate by a majority vote. That means that two branches of the government are in control of deciding who gets to be a federal judge. And that's true of federal district judges, Court of Appeals judges, and judges of the Supreme Court. They have a lifetime term. Now, what do you do if you have someone who does something evil, someone who takes bribes, for example, or blatantly breaks the law? Well, there is a provision for impeachment. The impeachment requires a federal judge may be impeached for a lack of good behavior. But the impeachment requires a majority vote in the House of Representatives and a 2/3 vote in the Senate, and it doesn't happen very often. I think less than 20 federal judges have ever been impeached, and less than 10 have ever been impeached and convicted and removed from office. And there have been hundreds of federal judges over the 230 years of our country's history. It doesn't happen often, but it says even judges are subject to the rule of law. Finally, there's one more provision in the Constitution that tries to protect an independent judiciary. That's a provision that says that the salary of a federal judge cannot be lowered during his term of office. Why is that there? Well, it's there because the framers of our Constitution recognized that one way you could threaten judges, if you couldn't fire them, is to cut their salary off. That would certainly toe the mark for a lot of people. If you had if Congress and the President got angry at the federal judges because they gave a ruling, say that the law was unconstitutional, you could bring them to heel by saying, well, judges, if you're going to do that, we're going to cut your salary off. And unfortunately, some people would give in to that kind of pressure. To remove that kind of pressure, a provision in the Constitution says that you can't lower the salary after they're in office. The long term, the lack of an election, or if there are elections as there are on the state level, infrequent elections to very long terms, and the fact that you can't lower the salary are three things that are meant to guarantee an independent judiciary. That is our attempt to do it. Now, there are some who would say the judges are abusive. There are some who would say, well, if you give a federal judge a lifetime term, you'll get judges who think they're above the law, who think that they are people who can't be removed. And they know that impeachment is very infrequent. There is another part to the independent judiciary, and that's the notion of an appeal. Our federal judges our federal district judges hold trials all across the country. Some of them are civil actions, some of them are criminal actions. But after the judge has heard the case, if he has not followed the law carefully, his judgment can be appealed to the next higher level. So, appeals to the Court of Appeals are granted in this country. And if you're not satisfied with the Court of Appeals, it is possible, not likely, but possible that you can appeal to the U.S. Supreme Court. So part of our independent judiciary are checks on the judiciary through the appellate process. Now, how does this all come together? Well, this comes together as a part of our notion of government itself. We're going to protect government. We're going to protect ourselves with government. We're going to try to protect ourselves from the government by having laws that regulate. So proposition number one of the rule of law is that all people, the government and the people, need to be under the rule of law. The people need to be under the rule of law, resolving their disputes through the court system, through the police, if they can't do so peaceably. The government is to be under the rule of law by requiring them to take an oath of office, to uphold the law, and by making them subject to judgments by the courts. And the courts, the third leg of the requirement is that there be an independent judiciary. It is in this way that we seek to preserve the rule of law. But what is law? The next segment of the rule of law will discuss the nature of law itself.